Good morning, everyone. Welcome to today's hearing, at which we're going to continue hearing closing statements from various core participants. Before we begin, however, I need just to explain that Mr. Akbor is unable to sit with us today for the very good reason that he's attending an investiture at Windsor Castle, where he will formally receive his OBE. However, he's asked me to make it clear that he will view the recording of today's proceedings at the earliest opportunity to ensure that he's fully informed of what's been said in the closing statements that we're about to hear. So, without further ado, I shall invite Mr. Leonard to make a closing statement on behalf of Carl Stokes and Associates. Yes, Mr. Leonard.
Good morning, sir. Good morning to your panel colleague. This is the third occasion upon which I have addressed the inquiry, and on each occasion I have offered an assurance that CS Stokes would cooperate with the inquiry, which it has done so through statements of significant length and by way of Carl Stokes himself giving evidence over a number of days. We have also submitted, for the purposes of this submission, a written submission, which is some 36 pages in length, covering 117 paragraphs. I have literally no intention of going through that, but on the other hand, it should not be thought that the brevity of my submissions to you today are in any way reflective of an unwillingness to engage. Quite the opposite. But it does seem to us that we would be better in trying to draw some strands together for you reflectively, and also in a way that perhaps tries to embrace what is to come in the future as much as what has gone on in the past. On each occasion as well, I have, and thus Carl Stokes himself has, expressed his deepest sympathies and condolences to the survivors, the bereaved, their relatives, and all others affected by the Grenfell Tower disaster, and that is repeated again through me today. So there is no doubt that the facade on the tower was the preeminent and dominant cause of fire spread on the 14th of June 2017, resulting in death and serious injury. As the panel determined in Phase 1, the facade manifestly did not comply with building regulations, primarily because of the way in which the fire spread. It is submitted that whilst the spread was, or should have been, foreseeable to some, it was not foreseeable to all, and I include CS Stokes in that. Your inquiry has a role specifically identifying what happened and why it happened at Grenfell Tower. It also has a forward-looking function in relation to the future of the design, management and fire safety of the built environment. In some respects, there has been a fluidity in the submissions that we have detected as between the specifics of what happened in the past and those matters that are concerned with the future. The inquiry is invited to be careful not to elide the two, and in particular to avoid simply characterising individuals, such as Mr. Stokes and Mrs. Ray, as villains of the piece. To do so in our submission would be to risk losing sight of some of the fundamental issues that existed structurally within the system that they were operating within. There was yesterday a degree of unanimity on the part of some core participants that Carl Stokes, on the strength of what was said by Dr. Lane, was, and I quote, reckless. In our submission, it is simply not possible to agree with that conclusion when it is set against the evidence of Colin Todd. I have to make and will make submissions on 4 topics in very general terms. Firstly, fire risk assessments. Secondly, fire risk assessors. Thirdly, the issue of competence going forward. And fourthly, briefly, in relation to the Fire Safety Act of 2021, which, as you know, has already changed the landscape of fire risk assessors and assessments before you've even completed your inquiries. Firstly, fire risk assessments. As you know, they were completed by Carl Stokes on behalf of the responsible person under the fire safety order, the KCTMO. I'm conscious that you're going to hear submissions from Mr. Maxwell-Scott as to how that responsible person is to be ordinarily identified, and underlining some difficulties with the fire safety order as it currently exists. However, the fact that Carl Stokes did the fire risk assessments does not mean that he was the, quotes, responsible person under the fire safety order. That duty remained with the TMO. Our understanding is that each and every of Carl Stokes' fire risk assessments were reviewed by the London Fire Brigade, as were fire risk assessments carried out by him for other buildings across the TMO's portfolio. It is perhaps unnecessary to point out that, despite all the manifest claims of inadequacy and failure since the fire, on no single occasion, as far as we are aware, was Carl Stokes' work called directly into question. Neither was there any issue as to his competency or experience thought sufficiently serious to bring it to his attention directly, perhaps therefore affording him the opportunity to do something different. That is not, in our respectful submission, a perverse observation. It is a matter of fact. Now, if that element of oversight on the part of the LFB is to be ignored, then so be it. But as far as Carl Stokes was aware, there was, as I say, no substantive concern about the work he was doing or the way in which he was carrying out that work. So we have made a number of forthright observations in our written submission as to how the Grenfell Tower inquiry should approach the evidence of Dr. Lane. It appeared obvious to us, although entirely a matter of view, I know, that when she gave evidence, Dr. Lane was often reluctant to engage with or speak to what a reasonably competent fire risk assessor would or should have done in Mr. Stokes' position. She was right to do so, and by that I mean the reluctance that she displayed. On the one hand, because she had and has, as I understand it, literally no experience of carrying out fire risk assessments at all for purpose-built blocks of flats pursuant to the fire safety order or otherwise. Insofar, therefore, as she offered a critique of the fire risk assessments for Grenfell Tower, her evidence in our submission needs to be approached with extreme caution, save perhaps for where it appears to signpost a way for the future as opposed to a reflective analysis of what has gone on in the past. You, sir, may well have comments to make about the relevant local government association guidance. You may additionally have comments to make about what is referred to as PAS 79, PAS 79. But to conclude that it would be unreasonable for C.S. Stokes, or indeed Janice Ray, to have deployed those documents as part of their approach would be, in our view, unsupportable. By way of example only from Dr. Lane's analysis, if indeed this was her suggestion, as I understood it, the suggestion that a fire risk assessor was in some way signifying or certifying that building works complied with building regulations, if that is what she meant, is to us an indication of just how out of touch she is or was with the relevant law and practice in this area. To assign the role of the fire risk assessor as the linchpin in fire safety, which is not supported by the law properly understood, we say, risks missing the opportunity to require far more fundamental change, which is crucial to avoiding a tragedy of this scale ever happening again. Yesterday, my learned friend Mr. Freeman, Queen's Counsel, referred to what I hope I can shorthand refer to as the Borough Authority. As I understood it, he may have been inviting you to consider applying that to Mr. Todd's evidence in some way, insofar it was out of step with a logical analysis. In that case, as we perceive it, experts spoke with one voice about an aspect of professional performance that appeared fundamentally flawed, and the judge declined to accept it. In this case, we submit that we only have one properly described expert, and that would be Mr. Todd in relation to FRAs, and another witness, Dr. Lane, who we submit is not an expert at all in that field. There is, we respectfully suggest, no evidential or logical basis upon which it could or should be concluded that Colin Todd's opinion, quotes, was incapable of withstanding logical analysis. And if that's right, Borough has no obvious application. And of course, sitting behind it, and that's Mr. Todd's opinion, is a wealth of guidance, all of which adopted by the government, and as we understand it, none of which has yet been replaced. In summary, if these were civil proceedings, and I readily accept they are not, we respectfully suggest that Dr. Lane's opinion on matters relating to fire risk assessments would be inadmissible. Now, that I accept, of course, is not determinative of how her evidence should be received by you, but is certainly informative in terms of the weight to be given to it. We submit that if there is a preference for opinion in this area, Mr. Todd's expertise speaks for itself. Even if, operating at the level he does, it would be hard for him to regard himself as representative of the ordinarily competent fire risk assessor. I move on to the fire risk assessors themselves. Retrospective analysis of the fire risk assessments and competence of the assessor is complicated. And you have Mr. Todd's analysis of those fire risk assessments and his conclusions in broad terms. The starting point is that all risk assessment is a subjective analysis of the circumstances that present, and not an objective one. And there's a sense in which that applies to any assessment of risk, whether in fire safety or health and safety more generally. That means that there may be a range of views which are potentially supportable, even if they do not all align with each other. The second point, and this is crucial to understanding not only analysis of fire risk assessments here, but also when one considers how the new Fire Safety Act of 2021 is going to be applied, is that the legislative intention behind the fire safety order was driven by a deregulation agenda consistent with the notion that the fire risk assessment should be capable of being undertaken by the responsible person. Competence to undertake that role is not further defined in the fire safety order, and you can look to Regulation 9 in support of that submission. Notwithstanding, therefore, the evidential reality that Mr. Stokes was competent and possessed the necessary experience for this role and qualifications, and you have Mr. Todd's comments in that regard, it remains perhaps remarkable, a remarkable indeed feature of the SFO, of the Fire Safety Order, forgive me, and one which might cause consternation is if looked through the prism of a different lens, that the Fire Safety Order itself does not firstly require fire risk assessors to be, quotes, competent, and therefore inevitably does not set out any criterion by which competence is to be assessed. That is not, of course, to say that fire risk assessments or assessors should be incompetent. It is to say that there is no obvious benchmark of competence. Now, it seems to us inevitable, perhaps even imperative, that this inquiry will have to make recommendations concerning competence going forward. and to advise the government in the strongest terms about how to develop the concept of the fire risk assessment against a background of competence criteria for those carrying them out. In other words, something of a departure from the deregulation notions that brought the fire service order, the fire safety order into existence. We have no difficulty in principle with that, of course, and that is for the panel to determine. But the question of what that will be and how it will operate is not easy. All are agreed that there are fundamental problems with the system that existed on and prior to the night of the fire, not least with the system of building control. That may mean that there were systemic failures, in other words, failures in the system and of the system, even if individuals operating within that system did so with a requisite standard of skill and care. And that might include, may it not only Carl Stokes, but those employed to oversee construction, clerk of the works, and LHC in respect of inspecting entrance doors. Can I turn, please, to competence for the future? There were, or rather still are, but to one extent one's already been answered, two key questions for us. Firstly, will the scope of the inspection for a fire risk assessment include the external envelope of the building? And the Fire Safety Act of 2021 has answered that question for us, but I'll come back to that in a moment. If it is, as it now does, although it's not yet in force in England, how is that inspection to be carried out and to what extent? And what will be needed by way of competence for those who are supposed to do it? The second issue, and this aligns with the proposition that in fact a fire risk assessment is a snapshot of a building's condition on a particular day, is whether or not this inquiry finds it appropriate going forward to identify the need for a continuing duty in relation to fire safety over and above that individual fire risk assessment on that particular day. As we perceive it, the inference to be drawn from a number of the BSR submissions is that the assessor cannot leave the building in the hands of the responsible person, that the assessor has to have a continuing duty thereafter, not just to identify fire risk issues, but to be responsible for fire risk management more generally and on an ongoing basis. If the answer to that is yes, that is what is required, how is that going to be managed and delivered? And how, frankly, is the current fire safety order to be interpreted as requiring or imposing such a duty upon a fire risk assessor assisting the responsible person for that purpose? It goes without saying, does it not, that the Fire Safety Act of 2021 itself goes nowhere near enlarging that responsibility. All it does is speak to the external walls and structure of the building. You will forgive me, I hope, just one final evidential comment within this section, because it is close to our concerns in relation to Carl Stokes and the external facade. You will, I know, bear in mind in general terms Mr. Todd's evidence that the external walls at the time did not form part of the fire risk assessment and had not been considered in that regard in that way. You will know that Mr. Stokes specifically drew the TMO's attention to the facade in his action plan of 2016 and invited them to ensure, I summarise, that the building regulations have been complied with. If they had been, it is arguable that we would not be here at all. On the face of it, Carl Stokes, as with others, reasonably relied on, but were misled by what building control did and said. Finally, sir, the Fire Safety Act of 2021. You will be aware that the Fire Safety Act of 2021 has now added, by reference to Section 1A of the Fire Safety Order, and I quote, "The building structure and external walls and any common parts are now," and I quote, "things to which this order, the Fire Safety Order, applies." With great respect, that is not, has been trailed in certain quarters an issue of clarification. That is plainly an issue of expansion. And we respectfully submit that that significant enlarging of the fire safety order brings with it profound implications for the way in which fire risk assessments are carried out for residential buildings. Not for a moment suggesting it shouldn't, but it does nonetheless have those profound implications. Primarily because the regulatory framework that brought the fire safety order into existence, which of itself anticipated that someone without any independently verified competence could carry out a fire risk assessment, has now had inserted into it an additional requirement that that person is able somehow to assess the structure and external walls of a building without any change to the person apparently enabled to carry out those fire risk assessments themselves. Inferentially, no such requirement in relation to structure and external walls pre-existed the Fire Safety Act 2021. However, you may like to consider the following. What qualifications are going to be needed for someone who is going to risk assess, quotes, the building's structure and external walls? How are they to discharge that assessment? What level of assessment is to be undertaken? How invasive? How extensive? Now, the inspection of the doors, about which you've heard a lot of evidence in the current inquiry, is instructive in this regard. We respectfully suggest that the idea that every door has to be inspected is on balance unlikely needed for a proper discharge of that duty. But if it were thought and said that for a proper inspection of a flat door in a high-rise building, every door has to be inspected so that a proper assessment of compartmentation can be made, how is that absolute requirement to be transposed onto a requirement for a fire risk assessor to assess the structure of the building and the external walls? Does it mean that, for example, cavity barriers would have to be inspected by a fire risk assessor on, for example, the 21st floor of a building? And if so, how? Is a fire risk assessor entitled or allowed to commission a separate report in relation to such issues in relation to the structure of the building and the external walls? And is he then entitled to rely on it? Because it seems apparent in some quarters evidentially that it is thought Mr. Stokes should never have relied on, or anybody else relied on, building control. Are they, though, in the future allowed to rely on some other independent assessment of that building structure? And if so, on what basis? So you may or may not be aware, I'm sure you are in fact, that the Welsh Government, by statutory instrument, has brought the Fire Safety Act of 2021 into existence now, and did so as of 1st of September. I don't know if the inquiry has managed to locate the Welsh Government's guidance on that new legislation. It's not very long, and it provides literally no guidance about how it is that the new enlarged fire risk assessment is to be undertaken. Now, in the background, one's aware that the Westminster Government is consulting widely on how that matter is to be pushed forward. But it is, in our respectful submission, instructive that as yet, with the Welsh Government having introduced it, there is no additional guidance as to about how that enlarged fire safety order is to be managed. We respectfully suggest that, firstly, it is wholly unrealistic, as matters stand, to suggest that and expect that a typical fire risk assessor is able to inspect the external walls of a building from the point of view of construction and cladding. The fact is that such an assessment hitherto has been in the hands of building control and its compliance regime, and of course the construction industry that put it there in the first place. It's perhaps obvious that this, as matter stands, cannot be regarded as a satisfactory way forward. However, if the responsible person is to provide or commission an individual, separate analysis of the external walls of a given building on the basis that it is outside the competence of the fire risk assessor to do so. How extensive is that assessment to be? At what time in a building's life and when? And as I've already said, is the fire risk assessor then entitled to rely on it? And how often is it to be repeated? In our respectful submission, in what only amounts to a few lines, the Fire Safety Act 2021 has introduced a fundamental and significantly structural change to the way in which fire safety is currently applied, without any apparent understanding of how to manage it. We respectfully suggest that that is an issue with which you may have to grapple. The way forward, sir, is not an easy one, but we hope that our submissions have been helpful in that regard.
Well, thank you very much indeed, Mr. Leonard. The next closing statement is going to be made by Mr. Maxwell-Scott, Queen's Counsel, on behalf of the Royal Borough of Kensington and Chelsea. Yes, Mr. Maxwell-Scott.
Mr. Chairman, Ms. Istefan, Mr. Akbor, the Council is grateful for this opportunity to make a final statement at the end of modules 1, 2 and 3. The process that has been gone through to reach this point has been uncompromisingly thorough. It has also been long. It has been over 4 years since this inquiry was set up. It has been over 3 years since the opening statements in Phase 1. During these years, the Council has at all times sought to assist this inquiry in its search for the truth. It has sought to put into practice the formal public commitments to candour that it has made. Part of doing so has been analysing the evidence with an open mind, not seeking to defend the indefensible, being self-reflective, assisting the inquiry by identifying areas where the Council fell short, making appropriate admissions. We hope and believe that the Module 3 witnesses who were supported by the Council's legal team each personally sought to adopt this approach to the inquiry. All of them were told that the Council's only wish was that they give truthful and factually accurate evidence. The Council has carefully considered the passages in the oral evidence where its witnesses accepted that they could or should have acted differently. In doing so, it has reflected on the admissions it made in its Module 3 opening statement and on whether it should make further admissions. The Council has identified further areas where it fell short and therefore considers that it should make further admissions. The admissions which it considers it right to make are set out in full in its detailed written closing statement. At this stage, I will identify the 7 admissions set out in the introduction to the Council's Module 3 closing statement. 1. The Council admits that the number of Council officers devoted to monitoring the TMO was insufficient given the number of residents whose properties were managed by the TMO and the scale and importance of a task delegated to the TMO. 2. The Council acknowledges that there was no RBKC document setting out what its residual responsibilities were under the fire safety order in respect to properties managed by the TMO. There should have been. 3. The Council admits that the officers in housing commissioning who monitored the TMO received no training on the Council's residual responsibilities under the fire safety order. They should have done. 4. The Council admits that the level of resident consultation envisaged by Volume 2, Chapter 2, Schedule 3 of the 2006 Modular Management Agreement was not achieved. 5. The Council admits that it was wrong to tell the TMO that the programme to install self-closers should be a 5-year programme rather than a 3-year programme, and that there should not be an inspection programme. 6. The Council admits that the by-borough corporate health and safety team was an underused resource and that greater use should have been made of it when monitoring the TMO. 7. The Council admits that housing commissioning should have made more use of the corporate health and safety team's expertise to prevent issues falling between the gaps. They failed to do so. The Council apologises unreservedly for its failings. As part of the process of analysing the evidence with an open mind, we've reread our written opening statements for Phase 1, Module 1 and Module 3. We did so because we wanted to see the extent to which they needed to be corrected in the light of all of the evidence heard since they were written. We have identified a small number of corrections, which are set out in full in our written closing statement. There is also one point that I need to correct in our Module 3 written closing statement. In paragraph 72, we stated that Carl Stokes had no direct contact with council staff after he was appointed, and footnoted a passage in Stokes' oral evidence. Whilst that is what Stokes said in oral evidence, it overlooks the oral evidence of Amanda Johnson, that she met Stokes after the Adair Tower fire, and documentary evidence that on a handful of occasions in the period 2010 to 2012, some council staff attended meetings at which Stokes was also present. Subject to those corrections, we believe that the council statements which I have mentioned remain accurate. Therefore, the panel, and anyone else seeking to understand the council's position on modules 1 and 3, should consider not only the council's closing statements, but also those 3 opening statements. As part of the process of analysing the evidence with an open mind, we've also carefully considered the closing statements of other core participants, in particular the bereaved survivors and residents. We noted that some of the themes in the council's closing statement also feature in their closing statements, but we also noted some important differences. I believe that it may assist the panel and others if I explain what I see as the underlying reason for many of the most important differences between the council's position and the BSR's position. In summary, the BSRs contend that the council and the TMO were jointly the responsible person for Grenfell Tower under the fire safety order. Team 2 submits that the council's responsibility was not residual, but a shared primary one. That would seem to suggest that the council's obligations under the fire safety order were in practice identical to those of a TMO. Given that analytical starting point, one can see why they conclude that the council's approach to the fire safety order was too passive. Our analysis starts in a different place. With the exception of the planning and building control issues explored in Module 1, the nature of the council's role was shaped by the fact that Grenfell Tower was managed for it by an independent organisation, the TMO. The council was the landlord. The TMO was the managing agent. The TMO, the council and the LFB all understood this to be the case. The fire safety order focuses on the control that an organisation has over a premises. Article 5 uses the concept of matters within a person's control. The control that the council had over Grenfell Tower was different from the control that the TMO had over it, because the council had delegated extensive management powers to the TMO. These powers included the operational management of the tower, but they extended far beyond that to include major work schemes and management of a capital programme. In other words, not just day-to-day management issues, but issues involving longer-term planning and strategic management. The council fully admits but it retained some control over the tower, and therefore continued to have some responsibilities for it under the fire safety order. But those responsibilities are better described as residual ones than shared primary ones. We therefore say that the BSR's analysis does not reflect how the fire safety order works. We also say that it overlooks some important factual considerations. TMO was an independent organisation. It was at arm's length from the council. It had its own arrangements for monitoring its performance and its own board. After his appointment in 2010, Carl Stokes had very limited contact with council staff, but a great deal of contact with TMO staff. The TMO alone attended the regular meetings with the LFB, rather than the TMO and the council attending jointly. All enforcement and deficiency notices issued by the LFB were formally addressed to a single recipient, the TMO. Our analysis is also consistent with Dr. Lane's observation that the TMO had the greatest control over Grenfell Tower due to the responsibilities delegated to it by the council. For these and other reasons, we cannot agree that the council's role and responsibilities were the same as the TMO's. They were not. The council funded the TMO. The TMO's role was to manage the council's social housing. The council's role was to scrutinise and monitor how the TMO performed its role, a role which the council admits it did not carry out as well as it could and should have done. Over the next 45 minutes or so, I will cover the following 7 topics: complaints, the management of fire safety, reporting by the TMO to the TMO board, scrutiny and monitoring of the TMO by the council, the plans to develop a borough-wide self-closure programme, law and guidance documents, and vulnerable residents. In the written closing statement, we have focused primarily on the position of the council. We've not attempted to address every issue that arose in Module 3. I will adopt the same approach in this oral statement. More detail and the supporting evidence for the points I make can be found in the written closing statement that will be available on the inquiry's website today. I turn first to complaints, which were the first topic explored during the Module 3 hearings. Complaint systems are important. Listening to complaints is important. Learning from complaints is important. A well-functioning complaint system has the potential to provide useful information about areas of service which are underperforming. A poorly functioning complaint system is less likely to do so. And perhaps most importantly, a poorly functioning complaint system increases the risk of a breakdown in trust with residents. The Council acknowledged in its Module 3 opening statement that a significant number of residents of Grenfell Tower felt very strongly that it was not being managed as well as it could and should have been. Some of them complained to the TMO, or to Ryden, or to the Council. Some of those who complained were dissatisfied with how their complaints were handled and did not feel respected. The evidence heard in Module 3 has identified a number of examples of the TMO complaint system functioning poorly. In our written closing statement, we have cited one particular example, the letter from the GTLA in September 2010 and how it was dealt with. This is the letter that Mr. Mansfield, Queen's Counsel, put up on screen yesterday. Our analysis of the evidence is that, over time, a perception developed within the TMO that the complaints it was receiving about Grenfell Tower were being driven by a small number of residents. Residents whose views were not entirely representative of the silent majority. As a result, there developed, at least to some extent, a presumption within the TMO that the substance of complaints made by those residents lacked merit. This mindset was also present within the council. When it was told one thing by residents and another thing by the TMO, it was likely to start out with the assumption that what the TMO said was correct. The result was that residents were not listened to as much as they should have been. This failure to listen fully to residents did not just apply in the context of complaints. It also applied in other areas of resident engagement. For example, the 2006 Modular Management Agreement included a schedule which contained provisions on how residents should be consulted during construction projects. The level of resident consultation envisaged by this schedule was not achieved during the Grenfell Tower refurbishment project. As a result, an important opportunity to listen to residents was missed. The Council's approach to resident engagement is now very different. Residents can get involved in decisions about what housing management services are provided and how they are provided in a variety of ways. One of these ways is through the Tenant Consultative Committee, which meets 11 times a year. Another of these ways is through attendance at the Resident Safety Panel. The Council also involves residents in task and finish groups to develop new policies. The complaints process is also different now. Before the fire, the TMO and the Council had separate complaint systems which were not interlinked. Now, the Council directly manages its social housing, and residents' complaints therefore come directly to it. They are overseen at the most senior level within the Housing Management Department at a weekly meeting chaired by the Director of Housing Management. The points that I've made about the position before the fire are about a cultural attitude towards complaints. I'm not suggesting that the Council should have been running the TMO's complaint system for it. Nor was it the role of a Council to look into the granular detail of all complaints submitted to the TMO, or to look into the granular detail of all complaints submitted to the TMO, which also happened to be copied to the Council. Undertaking such a task would, as a matter of principle, have been inappropriate, given the TMO's independence, arm's-length status, and own governance arrangements. It would also have involved a duplication of resources. In our written closing statement, we consider in more detail how the Council was monitoring the TMO complaint system and what additional steps the Council could and should have taken. We state that the Council should have convened a complaints meeting, which according to the TMO Monitoring Procedure Guide was intended to be chaired by the Cabinet Member for Housing and attended by the TMO complaints team. The Council should also challenge the TMO more on complaints at the regular officer level meetings, which did take place. The Council should have been conscious of the limitations of the systems in place to enable it to monitor the TMO's complaints system. It should have been more aware of the need for it to keep an open mind about whether residents' complaints had merit. It should have been more aware of the need for it to keep an open mind about whether the TMO's complaint system was functioning well. In many respects, it was desirable for the Council and the TMO to work closely together and for there to be good working relationships between the officers of both organisations. But the Council should at all times have borne in mind that the TMO was an arm's-length organisation, which it had a duty to monitor. It would never have been easy for the Council to strike the perfect balance in relation to complaints between working with the TMO and serving as a critical friend to the TMO. The Council admits that it did not get the balance right. It should have been more willing to challenge the TMO. It should also have been more proactive in looking for and encouraging the TMO to look for patterns in the complaints that the TMO received. Did the complaints from Grenfell residents, which the Council knew about, reveal a pattern in relation to fire safety? Were they a warning sign that there was a serious fire safety problem at Grenfell Tower. Others may disagree, but we consider that looking at the matter objectively and without the benefit of hindsight, the answer to both questions is no. We have considered these questions in some detail in our Module 3 opening and closing statements. I don't propose to go into that detail in this oral statement. What I invite the panel to do is this. First, recognise that the best evidence of the issues which were troubling a significant number of residents as the refurbishment was being completed is 1, the December 2015 petition, 2, Mr. Defan's speech to the Housing and Property Scrutiny Committee in January 2016, and 3, the matrix of outstanding issues emailed to a number of councillors and council officers on the 4th of October 2016. Secondly, I would invite the panel to focus on the totality of what was said on those occasions and on how those who read or heard what was said would have reacted, and to do so without applying the benefit of hindsight. I turn now to my second topic, how fire safety was managed in properties that were owned by the council but managed by the TMO. From 2010 until the date of the fire, the two key people involved in this were Janice Ray and Carl Stokes. In this oral statement, I'm going to restrict myself to outlining the key points of the council's position. The evidence that supports it is set out in detail in the written closing statement. First, Janice Ray, who was the TMO's Head of Health and Safety and Facilities. The council's position is that 1. She was the competent person for the purposes of Article 18 of the Fire Safety Order. 2. It was appropriate for her to be the competent person. 3. Neither the council nor the TMO board were told that she was overstretched. 4. She was overstretched, but was reluctant expressly to ask for additional support. Both Ray and her line manager Barbara Matthews recognised with the benefit of hindsight that Ray had needed additional support, but regrettably that recognition came too late. I turn next to Carl Stokes. Between 2010 and 2017, he was in effect the sole provider of fire risk assessments to the TMO. I'm not going to be addressing you on whether his fire risk assessments were in fact suitable and sufficient, as the council was not provided with those risk assessments at the time. My focus is on whether any concerns about Stokes were raised with the council. Our analysis of the evidence is that 1. Neither the council nor the TMO board were told that there were any concerns about Stokes' competence or the quality of his work. 2. The TMO did not have any concerns about his competence or the quality of his work. 3. The LFB raised concerns about Stokes with the TMO in 2015. 4. These concerns were raised with Ray and Matthews, but did not cause them to alter their positive opinion of Stokes. 5. The LFB's concerns were not communicated to the TMO board or the council. Fire risk assessments are another area where the systems in place now are very different from when the TMO managed the council's housing. The council contracts with external organisations to carry out Type 1 fire risk assessments. Approximately 15% of the council's fire risk assessments are then audited by an independent organisation. Last year, 64 out of 475 were audited. Where appropriate, the council also commissions Type 4 fire risk assessments. In addition, the council's internal housing fire safety team has the necessary accreditation to enable it to review the fire risk assessments produced by the external organisations. I now turn to my third topic, the issue of reporting by the TMO to the TMO board. During the Module 3 hearings, an important theme emerged, which we characterise in our written closing statement as the TMO executive team and officers not reporting negative developments to the TMO board. A number of examples of this could be given. We pick out 3 in our written closing statement. They are: 1. What the TMO board was told about the report by Matt Hodgson into the TMO's management of health and safety. 2. What the TMO board was told about the Adair Tower deficiency notice in 2015, the Adair Tower fire 3 weeks later, and a subsequent enforcement notice. And 3. What the TMO board was told about concerns raised about Stokes' competence. We don't seek to speculate as to why the TMO sometimes did not tell the TMO board about negative developments. But we do invite the panel to consider the evidence in relation to this phenomenon and to make factual findings identifying the instances on which the TMO board was not informed about relevant negative developments. Why does it matter if the TMO board was not told bad news? The answer is that under the arrangements for the management of a council's social housing stock, the TMO board had a vital role to discharge. As we have consistently submitted, the TMO was independent of the council. It came into existence in the mid-1990s because a majority of residents who were balloted voted that it should come into existence and should manage the council's social housing. In April 2002, an extraordinary general meeting of the TMO voted to amend the TMO's constitution to enable it to operate as an arm's-length management organisation. In principle, the TMO was run by the TMO board. All members of the TMO board were statutory directors of the TMO, which was a company limited by guarantee. The TMO board members' handbook was very clear about the role and status of members of the TMO board. It stated that the company was managed by the TMO board. It stated that the TMO board met on a regular basis to direct the strategy of the company, monitor how well the group was doing, and agree plans and policies for the future. It stated that the board determined the strategic direction and policies. The structure of the TMO board was designed to safeguard the TMO's independence. Under the TMO's Memorandum and Articles of Association, the majority of TMO board members were required to be residents and to have been elected by the membership of the TMO. An analysis of the minutes of the TMO board and the reports submitted to the TMO board reveals how it operated in practice. Those documents are not full of instances of a TMO board being told what to do by the council. Quite the reverse. The documents reveal that advice and recommendations to the TMO board were consistently presented to the board members on the basis that decisions to be made were their decisions to take. This is why what the TMO board was and was not told matters. It was an independent decision-making body. It was responsible for managing the TMO, directing its strategy, and managing its performance. As a matter of logic, achieving each of these tasks would be more difficult if it was not told about negative developments, if it was only told good news and not told bad news. Similarly, as a matter of logic, the role of a council in monitoring the TMO's performance would be more difficult if a council was not told about negative developments. It is the council's role in monitoring and scrutinising the TMO that I turn to now. This is my fourth topic. The first point to make might be considered a slightly pedantic one. Monitoring and scrutiny are not the same thing. Scrutiny has a specific meaning in the context of local government. It should only be used when speaking about the work of a scrutiny committee. Monitoring is the correct term to use when referring to all other forms of overview by the Council of the TMO. We explain this in more detail in our written closing statement, where we also analyse the work of the Housing and Property Scrutiny Committee. In this oral statement, I will focus on the Council's monitoring role. I'm not going to say anything about the many different ways in which the TMO board and the TMO executive team monitored the TMO's own management of housing generally and fire safety specifically. But those arrangements must be borne in mind when analysing what the Council did and did not do. The Council was not, and was conscious that it was not, solely responsible for monitoring the TMO's performance. It should not be treated as if it was. When disaster strikes an organisation, people tend to look back for certain telltale signs that it had been dysfunctional or failing. Signs such as an increase in the number of complaints, poor annual performance reports, failing to meet important KPI targets, high turnover of staff in senior positions, inability to fill senior positions, declining membership, declining levels of confidence in the organisation amongst its members and residents. Where a number of such signs are present, panels such as this one are rightly encouraged to infer that warning signs were present, which could and should have been heeded. The balance of the evidence presented to this panel does not portray the TMO as a typical dysfunctional or failing organisation in the years immediately preceding the Grenfell Tower fire. The overall assessment of the TMO as set out in the annual and mid-year performance reports was consistently positive. The TMO generally met the KPI targets set by the Council. The TMO's Chief Executive, Robert Black, joined the TMO in 2009. Its Head of Health and Safety, Janice Ray, was already employed by the TMO at that time. Both remained in post until after the fire. At the time of the fire, the TMO had 3 executive directors. Their dates of appointment were 2010, 2012 and 2015. The TMO board had the same chair from 2012 until after the fire. The TMO did not have any unfilled senior management positions in the 2 years before the fire. The TMO's membership increased by almost 500 members per year in the period 2012 to 2016. It increased further in the 12 months before the fire. Under the modular management agreement, a test of opinion was required to be carried out every 5 years. The last one before the fire was in 2013. The TMO hired a third-party organisation to run the test of opinion. Of those who voted, 86% voted for the TMO to continue managing their homes. At the last AGM before the Grenfell Tower fire, 98.3% of those who voted were in favour of the TMO continuing to manage the homes. All of these matters suggest that the TMO was a healthy organisation that was performing well. Of course, I acknowledge that this was by no means the complete picture. The TMO's annual complaints reports reveal a sizable increase in complaints in the year 2015-2016. Much of the content within the annual and mid-year performance reports was written by the TMO itself, which obviously affects the weight that could reasonably be placed on them. The KPIs set by the Council did not include any in relation to fire safety. The Council has admitted that they should have done. But the story of the TMO is not a simplistic tale of an organisation that was obviously dysfunctional or failing. And we maintain our submission that the evidence available to the Council in the years before the Grenfell Tower fire suggested that overall, I stress overall, the TMO was an improving organisation with effective governance arrangements. Finally, on this issue, we invite the panel to understand the thinking of Council officers at the time. In her witness statement, Laura Johnson made the following point. When I started working at the Council, I took the view that the success of a TMO would be in part enabled by having a relationship with the Council which had clear boundaries of responsibility. The function of management lies with the managing agent. When Amanda Johnson gave oral evidence, she told the inquiry, people wanted the TMO to succeed. When the panel considers how the Council should have monitored the TMO, it should bear in mind that more intensive monitoring would be likely to involve further duplicating what the TMO and its board were themselves doing. And more intensive monitoring of the TMO would not necessarily have identified some of the performance issues within the TMO identified during the Module 3 hearings. TMO officers did not always inform their own board about negative developments. None of this is intended to imply that the Council's monitoring of the TMO was without fault. It was not. The Council admits that it should have monitored the TMO more intensively than it did, less passively than it did. The Council has identified a number of specific areas in which it fell short. They are set out in our written closing statement, but I will read out the more important ones now. Council admits that there was no RBKC document setting out what its residual responsibilities were under the fire safety order in respect of properties managed by the TMO. There should have been. Had such a document existed, it would have assisted officers and councillors to scrutinise and monitor the TMO. The fact that such a document was not created at the time that the MMA was revised in 2006 and 2015 represents a missed opportunity. As previously admitted, the Council acknowledges that it did not follow all of the procedures set out in the MMA and the TMO Monitoring Procedure Guide. The Council admits that the number of Council officers devoted to monitoring the TMO was insufficient, given the number of residents whose properties were managed by the TMO and the scale and importance of the task delegated to the TMO. The Council admits that the officers in housing commissioning who monitored the TMO received no training on the Council's residual responsibilities under the fire safety order. They should have done. The Council admits that the by-borough corporate health and safety team was an underused resource and that greater use should have been made of it when monitoring the TMO. The corporate health and safety team's understanding was that the TMO did not fall within its remit, but this understanding was not expressly stated within any RBKC document. Liaison and communication between the TMO and the corporate health and safety team was informal and took place on a less regular basis than the liaison and communication between RBKC's housing and commissioning team and the TMO. Housing commissioning should have made use of the corporate health and safety team's expertise to prevent issues falling between the gaps. They failed to do so. In July 2014, the LFB sent the Council 2 guides for councillors on fire safety. Councillor Guide on Fire Safety for use during Council meetings and Councillor Guide on Fire Safety for use during estate visits. The Council should have ensured that both guides were forwarded to all councillors. It failed to do so. The evidence indicates that the guides were overlooked by those councillors who did receive them. The Council admits that it should have made more use of these documents. I turn now to my fifth topic, the plans to develop a borough-wide self-closer programme. The Phase 1 report found that on the night of the fire, a number of flat entrance doors remained open because their self-closing devices were not present or not working. The spread of smoke through those open doors became the primary cause of the spread of toxic smoke during the fire. Earlier in 2017, there had been discussions between the TMO and the Council about putting in place a programme to inspect flats managed by the TMO and, where necessary, install working self-closers. There had also been discussions about whether, in addition, to introduce a programme of periodic inspection of flats with self-closers to check that they remained present and working. Neither programme had begun to be rolled out before the fire. The Council admits that both programmes should have begun to be rolled out before the fire. The Council admits that Laura Johnson was wrong to tell the TMO that the programme to install self-closers should be a 5-year programme rather than a 3-year programme, and that there should not be an inspection programme. Laura Johnson accepted this herself when she gave evidence to the inquiry. Laura Johnson also accepted, as does the Council, that the estimated cost of the two programmes was a factor, although it was not the only factor. The Council also admits that the Housing and Property Scrutiny Committee should have been told that consideration had been given to introducing an inspection programme, but that it was not currently being taken forward. The minutes of the May 2017 meeting of the committee record that it asked a question about flat entrance doors. That was an appropriate opportunity to inform the committee about this issue, an opportunity that should have been taken, but was not. The Council does not seek to qualify these admissions, but it does seek to ensure that they are seen in their proper context. That proper context is explained in some detail in our written closing statement, but it can be summarised in 6 key points. Those 6 points are: 1. The TMO did not make a formal request to the Council for the additional money required to fund an inspection programme. 2. The TMO executive team did not put forward to either the TMO board or the Council a strong or compelling case for an inspection programme. 3. Before the Adair Tower fire, there appears to have been a genuine misunderstanding between the TMO and the LFB as to what the LFB expected of a TMO in relation to self-closers. 4. Janice Ray and Barbara Matthews were aware of the passages about self-closers in the LGA guide, but did not bring them to the attention of the Council. 5. The TMO's internal thinking was marred by a mistaken belief that there was no regulatory requirement to inspect self-closers. It was also influenced by a belief that implementing an inspection programme would be virtually impossible, and that the LFB was not requiring similar organisations to have such a programme. 6. These thought processes influenced the TMO's thinking throughout the period, November 2015 to June 2017. All of this meant that in the discussions that took place between the TMO and the Council, the TMO failed to make the best case for an inspection programme and a 3-year installation programme. And as a result, Laura Johnson's response to the TMO was based on imperfect information. What I've said so far on this topic has been about the position across the council's housing stock managed by the TMO. It has not been about Grenfell Tower specifically. I now turn to the position with Grenfell Tower. The first point to make is that Grenfell Tower was one of the buildings which was part of the flat entrance door replacement programme. This programme took place between 2011 and 2013. During it, approximately 1,200 new flat entrance doors were installed across the borough. Within Grenfell Tower, 106 of 120 flats had new flat entrance doors installed during the programme. All of those 106 new doors were fitted with self-closers at the time of installation. Dr. Lane has identified 3 reoccurring faults that arose with the doors installed in the programme. During the Module 3 hearings, there was a good deal of evidence about who within the TMO knew about these matters, but there was no suggestion that the council was aware of them, and there was no evidence that anyone from the council was made aware of them. During Phase 1, the inquiry heard evidence that a handyman employed by the TMO had disconnected a number of self-closers within Grenfell Tower. This evidence was included in one of Dr. Lane's reports and came as a complete surprise to the council. The council's surprise was genuine and justified. The Module 3 evidence is now complete, and there has been no suggestion or evidence that anyone from the council knew about the handyman's actions. The council is very conscious of the recommendation in the Phase 1 report that owners and managers of every residential building should be required by law to inspect self-closers every 3 months. Despite nearly 2 years having passed since that recommendation was made, there has been no change to the law or guidance on self-closer inspections. Throughout that period, owners and managers have been left without a clear indication from central government on how frequently self-closers should be checked. Whilst it awaits guidance from central government, the council has been installing external overhead door closers to enable more regular visual inspection. This year, it also ran a self-closer inspection pilot programme. This programme was intended to trial implementing the recommendation in the Phase 1 report in 5 of its tower blocks. The Council is now waiting for further direction from central government on how frequently inspection should take place. The Council would urge the Government to provide the necessary direction as soon as possible. I'm moving now to my 6th topic, a completely different topic, one which is much more about the panel's role in making recommendations than about the Council itself. Law and guidance documents. The inquiry's terms of reference invite it to consider the scope and adequacy of fire regulations and guidance. This means that the panel will need to decide how to interpret legislation where it has not previously been interpreted by the courts. It will need to consider what to make of guidance documents intended to explain the effect of that legislation. Guidance documents which sometimes disagree with each other. The panel will need to assess what was common practice at the time, what was acceptable practice at the time, and whether there were instances when common practices fell short of what was acceptable. We respectfully suggest that it would be extremely helpful to the entire social housing sector if the panel took this opportunity to identify weaknesses in the fire safety order and the confusion created by it and its associated guidance documents. In this oral statement, I will focus on one of the 2 examples of confusion in the fire safety order that we identify in our written closing statement. In our submission, there is widespread confusion about the identity of the responsible person within both fire and rescue services and the housing industry. In our written closing statement, we list numerous examples that establish this proposition. Today, I will use just one of them. Andy Jack was the LFEPA's head of fire safety enforcement. He told the inquiry that he was one of the authors of the fire safety order. He also told the inquiry that he found it very difficult to reach a view on who was the responsible person in relation to housing stock managed by the TMO on behalf of the council. That is a striking statement, because a situation in which a building is owned by one organisation but managed for it by another is hardly unusual. Yet here we are, over 15 years after the fire safety order was passed, and there is still no authoritative answer on whether the responsible person is the owner or the managing agent, or whether both are the responsible person. This lack of clarity is, as I've sought to explain, a major reason for many of the most important differences between the Council's position and the BSR's position in Module 3. More widely, it is extremely unhelpful for those who work in fire and rescue services and the housing industry. And what makes the situation deeply concerning is that this problem has been known about within central government since 2009, but nothing has been done to remedy it. We therefore urge the panel to grasp this opportunity to resolve the confusion by analysing the fire safety order and providing a clear statement of who is the responsible person in such a situation, or by making a recommendation that the legislation be amended in order to clarify the position. Next, some observations about guidance documents. The first and most important point to be made is that whatever their imperfections, guidance documents are essential. The duties imposed on the responsible person by the fire safety order are often expressed in vague language, using phrases such as so far as is reasonably practicable, suitable, sufficient, and appropriate. It would be unrealistic and unreasonable to expect each responsible person to decide for itself what in practice the legislation required it to do. In the wider world of health and safety, it is normal for the Health and Safety Executive to publish guidance documents to assist duty holders to understand legislation and comply with it. Fire safety is slightly different because there is no single national institution equivalent to the HSE. But the proposition that duty holders need guidance to understand legislation and comply with it remains equally valid. And if there were any doubt about this, it is resolved by Article 50 of the Fire Safety Order itself, which states, the Secretary of State must ensure that such guidance as he considers appropriate is available to assist responsible persons in the discharge of the duties imposed by Articles 8 to 22. Therefore, responsible persons for purpose-built blocks of flats needed to have access to authoritative, practical guidance tailored to such buildings. The evidence which we set out in our written closing statement clearly indicates that the LGA guide was intended to fulfil that need and was widely regarded at the time as doing so. This is not to say that we think that the LGA guide was perfect. Far from it. Our submission that the panel should take this opportunity to identify weaknesses in guidance documents applies just as much to the LGA guide. The BSR's legal teams submit that the LGA guide was unfit for purpose. They also submit that the advice in it relating to vulnerable residents was unlawful because it diluted the clear requirements of the fire safety order. These are powerful submissions which deserve careful consideration. The panel should not flinch from accepting them if it considers it right to do so. Our point is a different one. We submit that it would be unrealistic and unreasonable to expect a responsible person to decide for itself what in practice the legislation required it to do. It would also be unrealistic and unreasonable to expect a responsible person to read every available guidance document and attempt to synthesize their contents for itself. What it would be reasonable to expect a responsible person to do is seek to identify the guidance document best suited to its building and then seek to follow the guidance in it. Put simply, the LGA guide was the guidance document that best suited Grenfell Tower. The introduction to it expressly stated that it was the more appropriate guide to use for purpose-built blocks of flats. The status of the LGA guide may well be looked at in more detail in Module 6, but the evidence we have seen so far suggests that this was an accurate statement of how central government intended the LGA guide to be regarded, and an accurate statement of how it was in fact regarded up until the time of the fire, and indeed after the fire, given that the Minister of State for DCLG told the House of Commons 12 days after the fire that the LGA guide was still current. My final topic is residents with vulnerabilities in the event of fire. It is an important topic and one to be approached with the utmost sensitivity. It may also be the most difficult topic for the panel to grapple with in Module 3. The difficulties that arise are both legal and practical. Responsible persons need guidance to understand what in practice they need to do. But the different guidance documents contain different advice. The practical problems flow from the fact that in general needs housing there is no expectation that the building will be staffed. There are no staff in the building when a fire breaks out. It is likely to be unrealistic to expect staff to enter the building in order to assist with evacuation. Position may be different in sheltered accommodation, but Grenfell Tower was not sheltered accommodation. It was a general needs block of flats. Mr. Chairman, your experts cannot agree on the solution to these difficulties, and I'm not going to attempt to provide one. I have already suggested that the LGA guide was the guidance document that best suited Grenfell Tower. In order to comply with the LGA guide, the TMO should have had in place and implemented systems for determining whether the number of people with disabilities in Grenfell Tower was likely to be different from a typical general needs block of flats. The TMO did not have in place adequate systems for doing so. The Council's monitoring of the TMO did not identify this. Although I am not offering to provide a solution to these difficulties, I will briefly say something about what the Council is doing now to address them. The Council and the LFB reached an agreement on how to approach the issue of residents who might need help to leave their homes in an emergency. The Council originally wrote to over 3,000 residents asking if they would need such assistance. Some of these residents were identified by the Council's fire safety team. Some of them were referred to that team by other teams within the Council. Some of them contacted the Council themselves. The council then analysed the information obtained. From this first set of letters, 293 residents were identified as needing a person-centred fire risk assessment. 201 have been completed, 92 residents declined one. As a result of the completed assessments, the council has prepared 123 PEEPs and has referred over 100 residents to the LFB for a home fire safety visit. This year, the council has written to over 5,000 residents asking if they would need assistance. 349 residents identified themselves as needing assistance to evacuate their home. The council is currently working to complete person-centred fire risk assessments with these residents. Mr. Chairman, that brings me to the end of the topics I wish to cover today. I have said quite a lot about the analysis that the council has done of its position. But this inquiry is not primarily about the council. It is the bereaved, survivors and residents who are at the heart of this inquiry. It is about them. The council's analysis is done in the spirit of serving its residents, assisting this inquiry and learning lessons for the future. The council is struck by what it has learned through this inquiry about the detail of how its buildings were managed, but it did not know or fully understand at the time. There is much that the council did not know, but it wishes it had known. There is much that the council wishes it had understood better. The council made admissions in its Module 3 opening statement. It has made further admissions in its closing statement. But the council remains very conscious that however hard it tries to analyse matters objectively, it can never be as objective as this panel, and that it is for the panel, not the council, to decide what its failings were. The council wishes to offer its sincere condolences to all those who have suffered loss and pain as a result of this tragedy, and to say sorry to each of the bereaved, everyone who survived, and all of its residents.
Thank you very much, Mr. Maxwell-Scott. Well, at that point, we'll take the morning break. We'll resume at 11:45 when we'll hear some further statements. Thank you very much. 11:45, please. Now, the next statement is going to be made by Ms Studd, Queen's Counsel, on behalf of the Mayor of London. So if you're ready, Ms Studd, come up to the lectern and you can address us.
Thank you. Mr. Chairman, in his opening, the Mayor invited the inquiry to consider whether the treatment of residents in Grenfell Tower demonstrated an institutional indifference based upon a perception that social housing tenants should be, and I quote, grateful for what was being provided for them, and I quote, for free. Having listened to the evidence called in Module 3, the evidence overwhelmingly supports the contention, and the inquiry should make a finding on this issue. The Mayor has previously highlighted the KCTMO's responsibility to act as a bridge between the tenants and their landlord, and to be a voice for the tenants and act in their best interests. That did not happen at Grenfell Tower. In reaching conclusions on Module 3, the inquiry will consider issues including, first, the KCTMO response to residents' concerns about safety. Second, the absence of any personal emergency evacuation plans, or PEEPs, to assist the disabled and vulnerable. Thirdly, the KCTMO's overall approach and response to deficiency notices. And fourthly, the manipulative behaviour of the KCTMO in limiting the transfer of information to the Scrutiny Committee and or the Management Board. The evidence has illustrated an arrogance by the KCTMO. Their attitude was that they knew better, and any concerns that were being raised by tenants were attributed to misinformation being fed from troublesome individuals to the other residents. There was no attempt to properly inquire about or investigate the residents' legitimate complaints, either by the KCTMO or, as RBKC have accepted this morning, by them. While the primary responsibility and ownership for health and safety at Grenfell Tower should have been with the KCTMO, for much of the period, it appeared that the only people really concerned about managing and resolving those issues were the residents themselves. Lee Chapman was concerned about the gas pipes being fitted into the only stairwell. His request for an independent survey was refused, and yet Rodney Hancock's, the expert instructed by the inquiry, agreed that the works had breached compartmentation and assisted the spread of smoke on the night of the fire. Eddie Defan's attempt to try and publicly record the condition in which residents were living and provoke a response from the KCTMO were not meant with any attempt to engage, but with a block placed on the server and legal advice sought in relation to libel. Shahid Ahmed raised a significant safety issue in relation to the smoke control system, of which he had first-hand knowledge following a fire on the 6th floor landing in 2010. In 2011, the KCTMO were made aware by their own contractors that the system was unfit for purpose. And yet, by 2017, with a newer system in place, there was still no system of inspection and maintenance. In addition, Beryl Menzies, the inquiry's smoke control expert, has concluded that the replacement smoke control system, as installed at Grenfell Tower, should never have been signed off by building control. It failed on the night of the fire. The lifts were clearly unreliable. Multiple residents repeatedly complained to the KCTMO about them. They were also substandard. Roger Hawkins, the inquiry's expert on lifts, told you that during the lift modernisation programme at Grenfell Tower in 2004, the lifts should have been upgraded to meet the requisite applicable standard, unless there were reasons to derogate from it. There has been no explanation of why they were not upgraded to firefighting lifts. Witnesses for the lift consultants working on this programme claimed that the KCTMO instructed that they did not wish to install firefighting lifts. KCTMO have been unable to produce any explanation for why this occurred. However, The result was that on the night of the fire control switch did not work, and the LFB were unable to gain control of the lifts, and it's believed that 3 residents died in the fire when they took the lift in an attempt to leave the building. The use of estate service assistants and caretakers to inspect and monitor issues of health and safety was clearly and obviously insufficient and ineffective. They were overworked and understaffed and were no replacement for an intrusive, standardised and regular inspection system. There was no compelling evidence of any intrusive regime on the part of KCTMO or RBKC to ensure the health and safety of residents, nor any appreciation that the tower represented not just a block of flats where, and I quote, £100,000 per flat was a gift from the state, but rather real homes for real people, citizens of the borough and a real community. As the Mayor foreshadowed in his opening, and the evidence has confirmed, the failures in communication and response by the KCTMO to those concerned about safety was widespread, not restricted to those that the KCTMO regarded as showcases, and it illustrates a culture of treating the tenants as sub-citizens and a subclass. The evidence has demonstrated that a human and empathetic approach to the residents of Grenfell Tower, recognising the flats as homes and a community, was lost. The frustrated tenants were determined to seek redress, but were regarded by the KCTMO as troublemakers, working to their own agenda and responsible for distributing misinformation. Their concerns should have been prioritised and resolved as far as possible, taking into account the obvious disruption of a major refurbishment. The inquiry has heard that 64% of the self-closing mechanisms on the doors were either not working or had been removed. Even in the teeth of a deficiency notice and the fire at Adair Tower, the KCTMO appear to have been more concerned with arguing about whose responsibility the self-closers were, rather than ensuring that residents understood the important contribution that they could make to fire safety. The rectification programme was delayed due to insufficient funds. The KCTMO had no system of regular inspection, despite knowing that they were a fire protection measure. Laura Johnson, the Director of Housing at RBKC, viewed the issue as a budget issue, requiring a 5-year period for remedial action to be completed, rather than as a fire safety preventative measure to assist in the control and spread of fire and smoke. She made no inquiries as to why it was that the LFB considered these failures important enough for a deficiency notice to be issued. Consequently, on the night of the fire, they were not repaired and offered no fire protection to the residents. The KCTMO also failed to comply with their duties and responsibilities in relation to the more vulnerable residents. The Salvus Review in 2009 had highlighted this significant omission, and as Dr. Lane identified in her report, the KCTMO's stated policy was to prepare a PEEP if a resident made their needs known to the KCTMO. However, that recognised duty was never fulfilled by the KCTMO, in part because there was no process to enable residents to communicate their needs. Dr. Lane confirms that there was no evidence of a PEEP being prepared for any resident of Grenfell Tower. Reliance on the local government guidance would carry some weight if the KCTMO, through its fire assessments, had satisfied themselves that Grenfell Tower was and remained suitable for the stay-put strategy. However, they did not, and they continued to act in breach of their own policy. So what was the KCTMO doing, and what oversight did RBKC actually have? The answer from the evidence called before you, Mr. Chairman, is very little, and very little. The KCTMO were aware that the LFB considered Carl Stokes' competence to be lacking, and yet they failed to take any steps to establish whether they were right or wrong. Any reasonable examination of the fire risk assessments would have revealed details of features that were not present at Grenfell Tower, such as the references to pigeon netting and balconies. This alone should have put KCTMO on notice that their fire risk assessor was taking shortcuts by cutting and pasting from other assessments. As she accepted in evidence, Janice Ray was aware at the time of two significant respects in which Carl Stokes was incorrect in his approach: the grade of the lifts and the responsibility for the maintenance of the self-closing doors. Those two issues alone should have put the KCTMO on notice that they needed to interrogate his competence and satisfy themselves that they had a competent person undertaking such important work. Had they done so, they might have discovered that he'd been given the role to assess the fire risk of the whole of the estate of 650 buildings, with only 11 months' experience and minimal qualification. Whatever the priority of the KCTMO was, it was not resident safety at Grenfell Tower, or arguably at the other 649 buildings within the estate. The engagement of Carl Stokes as the fire risk assessor again demonstrates the culture of the race to the bottom. There is clearly a need to impose a regime that will strengthen the required qualifications, competency, and demonstrable adherence to the standards of those conducting fire risk assessments. In March 2021, the Mayor wrote to the government urging them to introduce a new duty for building owners and landlords to share fire risk assessments with the occupiers, as well as with prospective purchasers and tenants of properties in a building. This would encourage a culture of safety to enable residents to consider issues of fire safety before they move in. In September 2021, the Mayor wrote an open letter to building owners and landlords, urging them to share vital building safety information with their residents on a voluntary basis. However, the Mayor believes that the imposition of a statutory duty would increase transparency in the housing market and mandate that all residents are in possession of the relevant fire safety information they need from the outset. The evidence before you, Mr. Chairman, has demonstrated a culture of failings in transparency and candour by the KCTMO, which, coupled with a lack of intrusion for RBKC, was a toxic combination. It allowed Peter Maddison, Director of Assets and Regeneration at the KCTMO, to control and modify what information he considered was appropriate to be put before the Scrutiny Committee or the Management Board, in accordance with what placed the KCTMO in the best light, and very often the residents in the worst one. Furthermore, minutes from the KCTMO meeting on the 14th of January 2014 record that Michael suggested that the fire brigade be advised of the volume of outstanding FRA actions. It went on, however, the consensus of the group was that this would result in more scrutiny from the LFB and also possible enforcement action, so agreed that we would not disclose this level of detail at this stage. Such an approach illustrates the very low level of importance that the KCTMO attached to the matters contained within the LFB deficiency notices. Where consideration should have been focused on risk and a need for swift resolution, it became focused on diverting scrutiny from the KCTMO failings. The evidence heard by the inquiry about the lack of protection afforded to disabled and vulnerable residents has also been truly upsetting and shocking. Dr. Lane's evidence that adults with impairments and children had a higher death rate than any other category of person at Grenfell Tower only illustrates further the effect of those gross failures. That 41% of disabled residents in Grenfell Tower died in the fire should fill us all with shame. The Mayor has responded to the government's recent consultation on personal emergency evacuation plans. He requested the government to go further than the consultation proposes, specifically stating that PEEPs should be available in all buildings covered by the fire safety order, regardless of height. The Mayor has also called for a central fund to be created so that the cost of developing PEEPs does not fall onto the residents they are intended to protect. The Mayor's London Plan 2021 makes provision for inclusive design and states that new buildings should ensure a safe and dignified evacuation for all residents. For example, London Plan Policy D5, Inclusive Design, requires that design and access statements submitted as part of development proposals include an inclusive design statement, and that where a lift is provided, it should be an evacuation lift. No one should be left without a plan and be required to evacuate their home by sliding down the steps on their bottom. The Mayor has already remarked upon the impact of budgetary cuts to the Building Control Department of RBKC and the effect that it had on the ability of building control to ensure compliance or conduct intrusive inspections. In this module, you heard a worryingly familiar account from Paul Hanson. The Means of Escape Committee reduced from 5 to 3 and then to him alone. That in turn led to a default system of certification without inspection and had a direct impact on the inspection and maintenance of the smoke control system at the Grenfell Tower. Mr. Hanson had little doubt that the absence of the mechanical and electrical engineer within the department impacted upon its ability to follow the Smoke Control Association guidance. There was too much work and too little time to undertake the role expected of him. The evidence of Paul Hanson has once again provided evidence of the correlation between funding cuts by central government and the reduction in public safety. Action is required to ensure that local authorities have sufficient funding for safety-related responsibilities and that it cannot be diverted to other concerns. As he stated in his opening to this module, the Mayor concludes that the evidence illustrates a pressing need to put in place measures to champion a stronger voice for London's tenants, especially those who are underrepresented or face significant housing-related inequality. The prolonged but unsuccessful effort made by the residents at Grenfell Tower to provoke the constructive response they were entitled to from the KCTMO makes it clear that residents' voices must be central to decision-making by councils and housing associations. There must be an open and transparent system to enable tenants to challenge their landlords to improve performance. There is an urgent need for better representation of social housing residents in the public sphere as well as on boards. Social housing must be placed at the heart of government plans to increase housing delivery and respond to chronic levels of shortage of housing needs in London. Social rented housing must not be treated as a secondary tenure. The Mayor has embedded new equality, diversity and inclusion funding conditions in the new Affordable Homes Programme 2021 to 26 to ensure that housing providers are held to high standards before they can secure public funding to support new homes. Delivery partners in receipt of a grant are now required to develop, publish and implement an Equality, Diversity and Inclusion Action Plan. As part of this, partners must deliver at least one action under the theme of working together with Londoners, which sets out how they will amplify the voices of residents and Londoners through their organisations' work. The Social Housing White Paper was eventually published on the 17th of November 2020, but much to the dismay of the bereaved survivors and residents, it was not mentioned in the Queen's speech, and thus far no government legislation has yet been proposed. The Mayor urges this inquiry to make recommendations as part of its report on this module to reflect the importance of the safety-first approach. The employment of competent fire risk assessors must take priority over cost, and the residents' voices must always be heard. Thank you.
Thank you very much. Well, now once we've done the usual housekeeping, we'll hear the closing statement from Mr. Seaward on behalf of the Fire Brigades Union. Yes, Mr. Seaward.
Good morning, sir, and Ms. Estefan, and assessors who are watching, and congratulations to Mr. Akbar on his OBE. Whereas a good health and safety culture takes leadership from the top, commitment, energy, time and resources to establish and maintain, it can be easily destroyed. The FBU contends the austerity cuts, deregulation and privatisation agenda of central government over the last 40 years, intensifying over the last 15 years, has diminished respect for health and safety, decimated public services, including building control and fire and rescue services, weakened the enforcement regime of fire safety rules, allowed ambiguity and confusion to pervade the guidance, and materially contributed to multiple failures in the application and enforcement of fire safety rules and regulations affecting high-rise residential buildings. We endorse BSR Team 2's submission that these forces contributed to a strong and pervasive political climate throughout this period in which regulation was viewed as a restraint of trade and business profit, a hostility towards health and safety regulation, the resultant creation of institutional indifference and neglect in which health and safety were paid little more than lip service, and a palpable disregard and disrespect for social housing residents, especially as we've seen in Grenfell Tower. The failures of the TMO's fire risk management system are more than individual failures. As seen in Modules 1 and 2, we have again in Module 3 witnessed the culture of complacency, aspiring only to minimal compliance with safety regulations. The FBU agrees and endorses the BSR submissions that these failures, allowed and in some instances encouraged by RBKC's failure adequately to fund or scrutinise the TMO's health and safety work, both contributed to the cause, I'm quoting here, both contributed to the cause of the fire and account for the overwhelming numbers of the dead who were either vulnerable themselves or those who stayed behind to care for them. That's BSR Team 1B's closing statement for Module 3. Module 3 is of great significance to the firefighters who attended and the control staff on duty on the night. They were confronted by a rapidly developing external fire, spreading through breaches of compartmentation as it re-entered flats and lobbies, all wholly outside their experience. The hazardous rain screen system should not have been installed, and having been installed, the rain screen cladding system should have been identified as an intolerable hazard by April 2016, at the latest by the fire risk management system, with fire risk assessment at its core. Once the hazard was theoretically brought to light, as it should have been, there would have been no practical alternative but to remove the rain screen cladding system and rehouse people from the tower until that was done. Additionally, the near total failure of all the active and passive fire safety measures allowed the rapid deterioration of conditions inside the tower, which grossly impeded the firefighters' operations, including search and rescue. If the TMO's fire risk management system had done its job, most, if not all, of the lives lost in Grenfell Tower disaster would have been saved. After her brief period of employment as Health and Safety Manager at Repairs Direct, Sharon McKinn stated, "Health and safety concerns were more talk than action." Her evidence has the ring of truth. Module 3 has also been characterised by an unjustified reliance by the responsible person on the Fire and Rescue Service to evacuate residents, including those especially at risk, in the event of fire in Grenfell Tower. The FBU is concerned that such reliance should not be countenanced going forward. Of course, the Fire and Rescue Service will attend and do its best at any fire or other emergency. But fire safety depends on everyone doing their bit, and that very much includes responsible persons developing and practicing building-specific evacuation plans for residents, including personal emergency evacuation plans, PEEPs, for those especially at risk, in the same way that employers do in office blocks and factories. This takes government leadership and resources to achieve. The government should not both delegate fire safety management to responsible persons and, as it did before the fire, deny it has thereby imposed a financial burden upon them to deliver it. If responsible persons are going to deliver fire safety for residents, they will have to adequately staff and resource their health and safety teams, their maintenance and repair programs, and their whole fire risk management system. We agree BSR Team 1B's analysis of the Grenfell Tower disaster through the prism of the near wholesale disregard of the residents' human rights by RBKC and TMO. The FBU has all along submitted that the inquiry may conclude the refurbishment project had gone off the rails from the start by the unlawful procurement of the services of Studio E and Ryden. Danny Friedman QC has drawn the threads together and shown how this disabled the TMO from challenging the architects and contractors and distanced it from the residents, who should instead have been at the heart of the project. The FBU has long campaigned for fire safety for the benefits of residents and firefighters alike. With very few exceptions, we are therefore able to agree all the closing statements of those representing the BSRs and adopt them here, thereby sparing the listener too much duplication. Just a few words on topic one. Residents' complaints cannot be trivialised and ignored any longer. The TMO's failure to take seriously residents' complaints about the issues listed below contributed to the disaster. Going forward, residents must be put at the centre of local social housing governance, as Ms Studd has just submitted, and be afforded accessible and independent dispute resolution in accordance with Article 6 ECHR. That's a very important part of this. Residents complained about front entrance doors, over 50% of which have since been found not to have self-closed, thus contributing to the spread of choking smoke inside the lobbies, lifts and stairwells on the night. The lifts, which were frequently breaking down and which couldn't be brought under the control of the firefighters. Delays with repairs, reflecting and evidencing the culture of minimal compliance. Running a gas riser up the stairs, reflecting and evidence the culture of not thinking fire and of minimal compliance, thereby contributing to breaches of compartmentation through holes in the walls from the stairs, through the lobbies and into the affected flats. The twos. Lack of accessible fire information. This had been inaccessible to residents from 2010 to 2016. The pre-2010 fire action notice, photographed by Shahid Ahmed, and you've got the reference in our written submissions, was eventually replaced by the one in place shortly before the fire, which we transcribed in our Phase 1 closing submissions. Whereas the pre-2010 notice had given simple and straightforward advice in the case of fire, get out and stay out, the one in place on the night of the fire was complex and conveyed the main and wholly different message, stay put. They complained about the floor numbering system, which misled firefighters on the night, and about the smoke control system, which didn't work at all for long periods before the fire, and appears not to have worked properly on the night, and to which the inquiry will return in due course. As to topic 2, the obligations of the TMO and RBKC under the fire safety order and their compliance therewith, the FBU notes the divergent opinions of Mr Todd and Dr Lane, and where they differ, invites the panel to prefer the opinion of Dr Lane. Our submission is explained in our written closing submissions, to which we refer you. In essence, Grenfell Tower was a complex building, and the external wall was a collective protection measure. The fire risk assessments of Mr Stokes were inadequate, as were the fire risk management systems of RBKC and the TMO. The FBU supports the call for clear competency requirements for fire risk assessors. As to topic 3, the FBU will again focus on the fire control switch for the lifts. I can hear you cheering, as we did in opening. We're going to approach this with the following structure. Having canvassed the lift issues fully in our written opening and closing submissions for Module 3, I propose today briefly to make a few preliminary points, to explain the importance of the fire control switch, to consider the evidence of the switch being blocked with builder's debris, show how this switch could not be operated by independent WSP inspectors, who I call WASP inspectors, using the correct size drop key with reasonable force on the 18th of April 2018, nor on the first attempt on the 19th of February 2019, nor at all until the builder's debris had been twice cleaned from inside the switch. And to submit that the likely reason why the switch could not be operated on the night was that it was blocked by builder's debris, that the expert evidence of Mr. Howkins on this issue, that the use of the wrong size drop key was the most likely cause of inoperability on the night, is unreliable. And to show why the witness evidence from Bureau Veritas and PEDAS is unreliable on the issue of testing the fire control switch before the fire, and to submit that there remains no reliable evidence that the fire control switch was working before the fire. So, a few preliminary points about the lifts. They were not firefighter lifts. There was no triangular key, which would have lessened the chances of a firefighter having a key with the incorrect dimensions, and they could not be used to evacuate residents from the tower. As Celotex have pointed out at paragraph 86 of their written closing statement for Module 3, but for Bourne & Young's and Apex's negligence and the TMO's disregard for fire safety, the issues encountered with the fire control switch may not have occurred. That's at page 39. It's not known which drop release key was used by firefighters on the night. There's no criticism of firefighters sourcing their own drop keys. And as Mr. Howkins acknowledges, it's the function of the panel to make findings of fact. The FBU asks the panel to conclude the fire control switch was not tested as Mr. Howkins has assumed and cannot be shown to have been operational before the fire. The importance of the fire control switch when operated by an express drop release key. The switch was supposed to cause both lifts to descend to the ground floor, the lift car doors to open, and thereafter to remain under the control of the firefighters and unavailable for anyone else because the call buttons higher up the tower should have been disabled. This is to protect residents from the known dangers of becoming trapped in heat and smoke in a lift car or lobby. The firefighters tried to operate the fire control switch as soon as they got into the tower and again soon thereafter. Crew Manager Secret at 1:01 and Crew Manager Gallagher at 1:34. The inoperable fire control switch may have had fatal consequences, whereas none of the residents would have been in the lift if the fire control switch had worked. Tragically, 3 fatalities were recovered in the lift lobby at floor 10. Additionally, the firefighters were deprived of a valuable firefighting tool which could have enabled them to get to upper floors quickly via the lift, carrying themselves and their equipment to reach higher floors than their standard duration breathing apparatus would otherwise allow, facilitating longer wears and by sparing them the long and exhausting climb up the stairs. I wonder if we could have the photographs, please. Thank you. We're going to see 2 photographs. One was taken on the 18th of April 2018 by the WASP inspectors in Grenfell Tower when the ground floor switch was first exposed after the fire. And we're going to see, that's that one. And I wonder if we could have these photos side by side. I don't know if that's possible. And the next one that's going to come up is the one taken on the 15th of February in the workshop at Deer Park. And I know that the panel have looked at these photographs closely before, but I'm going to ask you to do it again. So, looking at the evidence that the fire control switch was blocked and jammed to builder's debris, you can see the notes made by the WASP inspectors for Operation Northley on the 18th of April on the left of the page. The fireman's switch was difficult to operate. That implies they tried to operate it. The faceplate was removed to determine the reason for failing to operate the switch. We discovered that the mechanism was seized, damaged, or deformed. So this necessarily implies that the WASP inspectors had tried to operate the switch, presumably using a drop key of the correct dimensions and applying reasonable force, and discovered as a result of that the mechanism was seized, damaged, and deformed. This was finally, and may I remind you, sir, for the first time accepted by Mr. Howkins at the very end of his oral evidence to the inquiry. That's day 165, page 119, at lines 5 to 17. Please note from the April 2018 photograph, that's the one on the left, the exposed inner mechanism, including the switch frame arms, was caked with builder's debris. I mean, just looking at it, it was caked. And that's both where the switch arms are supposed to go up and down, operated by the drop key going through the gaps on the side, are supposed to operate the switch arms to turn them on and off. And we can see that there's builder's debris on the surface on which those switch arms are supposed to rub up and down. Compare that with the much cleaner switch shown in photograph 19, taken on the 19th of February. So BJG/74 is the one that was in Grenfell, but it doesn't bear comparison with the photograph of the fire control switch as it was when it was first revealed in Grenfell. Clearly, by the time photo 19 was taken, the internal faces of the fire control switch had been substantially cleaned. We can see shiny bits in there which are wholly invisible in the one that came out of Grenfell Tower. Following their inspection of the fire control switch on the 15th of February 2019 in a workshop at Deer Park to determine why it wasn't working, Andre Horn and the other inspectors reported, and I quote, "Also, the micro switch was jammed. It appeared to be a wall plaster during the works. During the examination, the micro switch became free and the micro switch operated. It's not known what caused the micro switch to jam, but there were plaster grains on the workbench. It's considered the build-up of builder's material on the top of the switch was from the original works and not caused by the extraction of the switch. This is also my opinion," said Andre Horn. The micro switches installed on BJG 74 operated correctly when the jam was cleared. So the word "also" indicates that there were two blockages or jams. The blockage noted on the 18th of April and the blockage of the micro switch. Clearing the debris from around the micro switch generated the 1/2 to 3/4 of a teaspoon of debris on the workbench that Mr. Hawkins described to the panel. Andre Horn reported on the 15th of February 2019 the switch frame arms of the ground floor fire control switch were found to be jammed. Now that's a different part. The switch frame arms are different from the micro switch. There was some debris evident on the frame, which appeared to be dirt, mortar, sand, possibly from the construction of the building. I'm quoting Andre Horn's report. After some gentle manipulation by hand, it moved freely. In our opinion, forceful manipulation of the fitting key would have moved the switch frame arms. The bent side wards and switch frame arm did not cause the jam experienced at the start of the examination. So it was the blockage that stopped the switch from operating. To recap, the fire control switch had not worked when firefighters tried to operate it on the night, when they're likely to have applied reasonable force to turn the key, nor when WASP inspectors tried to operate it on the 18th of April. It was then taken to Deer Park, where it was again found to be jammed, and thereafter it didn't work, until after some gentle manipulation by hand, it moved freely. The key to understanding these blockages, if you'll forgive the pun, is that independent WASP inspectors could not turn the correct size drop key in the fire control switch on 2 separate occasions due to blockage, 18th of April in the Grenfell Tower and 19th of February in the workshop at Deer Park. It's not just the firefighters who couldn't turn it with possibly the wrong key. It was WASP inspectors who must be presumed to have been using the right size key. We asked the panel to infer and find that both the switch frame arms and the micro switch were blocked by debris. The debris seen in the photograph taken on the 18th of April has not been measured, but must have been more than 3/4 of a teaspoon and must have been cleared before the photograph was taken on the 19th of February, including the switch frame arms. And I refer to the shiny bits on photo 19. The 1/2 to 3/4 teaspoon of debris cleared from around the micro switch on the 19th of February was another blockage, which had prevented the switch from being operated until it too was cleared by gentle manipulation by hand, and it was only after both blockages had been cleared that the fire control switch worked. The blockages would have prevented firefighters operating the switch on the night, whichever type of drop key was used. That's why the firefighters were unable to take control of the lifts, as they repeatedly tried to do. The panel has to have regard, of course, to Mr. Hawkins' contrary opinion, that it was probably the use of the wrong key, which prevented firefighters from operating it on the night. The FBU invite the panel to differ from Mr. Howkins on this point. Firstly, it cannot be determined which key or keys the firefighters used on the night, and so this is an unsatisfactory basis on which to impugn them for purportedly using the wrong key. Secondly, there is no independent or documentary or reliable evidence that the switch was tested and found to be working in the 16 months leading up to the fire. I'll come to that in a moment. Thirdly, Mr. Howkins has not properly, if at all, factored into his opinion that not just firefighters, but WASP inspectors using the right key could not operate the switch on two occasions, April 2018 and February 2019, before the blockages were cleared. Mr. Howkins came late, this is the fourth point, Mr. Howkins came late to the issue of blockage and only after then did he review his already reached conclusion. For these reasons, the expert evidence of Mr. Howkins on this issue, that the use of the wrong size drop key was the most likely cause of the inoperability on the night, is unreliable in our submission. Thank you for putting those photos up. I think they can come down now. Thank you. For these reasons, yes, in his first report, Mr. Howkins did not address the possibility that the fire control switch did not work because it was blocked by debris. He first addressed this possibility in his supplemental report of April 2021, when he discounted it on the principal ground that the Peters and Bureau Veritas engineers had found it to be working before the fire, to which I'll turn in a moment. In his evidence before the panel, Mr. Howkins initially attempted to dismiss the WASP inspector's inability to operate the switch in Grenfell Tower on the 18th of April by suggesting he may not have tested it because he may have been asked by the police to just remove it. That's at day 665, page 104, line 1. But Mr. Howkins later accepted, as I've already said, that the WASP investigator had tried to operate the switch and discovered that the mechanism was seized, damaged and deformed. But as I said earlier, this came right at the end of his oral evidence before the panel. And by that stage, he'd given all his evidence. He wasn't then further questioned about it, what effect that might have upon his opinion. But in our submission, he didn't sufficiently, if at all, take into account the inability of independent investigators, the WASP inspectors, using reasonable force and the right drop key to operate it due to its blockage with builder's debris, both on the 18th April and the 19th of February. We ask what changed between those two failed attempts and the successful attempt later on the 19th of February. And that's where the photographic evidence comes in. Turning, if I may, to the evidence from Bureau Veritas and Peters, because this is the second plank of Mr. Howkins' opinion, that they said they tested it and so it was working before the fire. Despite the track record of lift maintenance contractors and engineers not testing the fire control switch, so there's no evidence of any regular testing of the fire control switch by the TMO's lift engineers, by the Gerald Honey Partnership, by Apex, by Calford Seaton, even though they were all supposed to do so. Mr. Howkins credits Bureau Veritas and Peters with having done so, specifically by Mr. Lassisi from Bureau Veritas on the 2nd of November 2016, and by Mr. Arnold from Bureau Veritas on the 10th of April 17, and by Mark Wallace from Peters on the 9th of May 2017. From their not noting any faults, Mr. Howkins assumes that the switch was operating shortly before the fire. Our reasons for submitting Mr. Howkins' assumption is wrongly made are fully set out in our written submissions and not repeated here. I just summarise them. As to inspections by Bureau Veritas, there's no documentary evidence that either the fire control switch or the fire recall was tested on any of these Bureau Veritas inspections. Such testing was certainly not reported as it should have been. The witness statement of Mr. Lassisi does not, on proper analysis, describe any actual pre-fire testing of fire control switch or the fire recall function. I ask you to find that his evidence takes the matter no further. The evidence of Mr. Arnold is not reliable enough, we say, to substantiate Mr. Howkins' assumption. His reports, this is Mr. Arnold's reports of his visits, make no mention of any testing to the fire control switch or the fire recall function. His explanation for not recording any such testing, i.e. that only defects would be reported, does not hold water. As an explanation for there being no record of such defects, there was no record either of any inspection or testing with a fire recall function or the disconnected fire control switch on the walkway level, leaving aside the blockage with builder's debris in the ground floor fire control switch, which obviously the panel haven't yet made a decision about. If these safety devices or features had been inspected or tested, then at least those two defects should and probably would have been recorded. They were not, and the inquiry may conclude the proper inferences that these control features were not inspected or tested on this occasion either. Mr. Arnold's statement that the lifts I inspected at Grenfell Tower on the 10th of April 17 were in good working order and demonstrated a good standard of maintenance and upkeep is contradicted by the long record of complaints from the residents and the history of poor maintenance found by Mr. Hackett. Thus, there is no documentary evidence and only partial self-serving and questionable witness evidence to support the proposition that Bureau Veritas engineers inspected the fire controls or tested the fire control switch or the automatic fire alarm recall before the fire. I accept it's totally different after the fire. Everything's different after the fire. The documentary evidence, in fact, points the other way because of the lack of any mention of the defects referred to above. Moreover, if the inquiry finds the witness statement, I've just made that point. As to the inspections of PEDAs, turning to those, the service visit reports from February 16 to the fire show no mention of the disconnected fire control switch on the walkway level, which should have been removed, or of the defective automatic fire recall function. No part of the standard form, e.g. a checkbox, directed or encouraged inspection or testing of firefighting controls. Those supposed to be monthly or weekly, the whole inspection regime slackened in the year from February 16 to January 17, when there were at most only 7 visits, with long gaps, each of several months between them. PEDA's inspections procedures. There was an annual electrical and mechanical safety device check referenced in the Field Service Handbook, which Mr. Wallace was asked about, and that included a fireman's switch, and it required an annual inspection. It indicated that safety checks of the fire control switch were supposed to take place annually, not monthly, as asserted by Mr. Wallace. The only documentary record of any actual check by PEDA's engineers, which might have covered such testing of the fire control switch, is the electrical safety switch check recorded in Mr. Haggerty's service visit reports for the lifts under the heading Works Completed after his Type S service visit on the 19th of February 2016, 16 months before the fire. Study of the service visit records shows this annual check was not repeated on the anniversary of Mr. Haggerty's February 2016 service, or at all before the fire. The only proper inference is that the annual check was not done in 2017, after completion of the works and after reconnection of the ground floor fire control switch. Mr. Wallace couldn't say either way. He was asked about it on day 163 at page 110 at line 25. Mr. Wallace said the PEDA's Field Service Handbook would have been in the van and couldn't remember what columns M1 and M2 stood for. But he agreed this set out a detailed procedure for the maintenance visits for both M1 and M2 type inspections. They did not cover the fire control switch. Mr. Wallace agreed that the only PEDA's documentation referring to a fireman's switch was the Field Service Handbook, as I just referred to, and that it wasn't covered in the monthly M1 or M2 checks. He prevaricated when asked, does that suggest the fireman's switch is only tested annually, not monthly? Asked about his witness statement, averring he checked the fire control switch on both the April and May visits, he said that his alleged practice of monthly checks came from my own training and experience as a lift engineer. In his witness statement, paragraph 7, Mr. Wallace referred to carrying out checks detailed in the maintenance schedule, but in evidence he didn't remember seeing the maintenance schedule. Both statements cannot be correct. Focusing then on Mr. Wallace's service visits on the 12th of April and the 9th of May 2017, shortly before the fire. His service visit reports make no mention of the fireman's switch or any electrical safety switch check, even though the May visit was a Type S. Nor was any mention made of such check for either lift or in the lift logbooks kept in the lift motor room. I've got the reference for that if you need it, sir. Mr. Wallace didn't remember his May visit, and couldn't say what Type S meant. Yet when later asked about his purported testing of the fire control switch, he said he specifically recalled testing the fire control switch on both visits because after the fire, he, and I quote, felt happy that I'd actually checked it and I knew it was working at the time. That's day 163, page 115, line 19. And asserted of checking the switch in May 2017 that, yeah, I can remember checking that switch. And that's the same day at page 115 at line 4. Mr. Wallace had no explanation for this discrepancy, i.e. not remembering the May visit, yet remembering checking the switch. When shown Philip Edwards' statement, that's his manager, his line manager, Mr. Wallace corrected his own assertion that Mr. Edwards accompanied him on one of his service visits to Grenfell Tower before the fire, saying it may have been Dave Watkins. Asked about the automatic recall system, Mr. Wallace said, as far as I'm aware, it didn't have it, but there plainly was one, albeit disconnected from the lift control box. The only proper inference is that he didn't inspect this fire safety device. Mr. Wallace's explanation in his witness statement that the fire control switch is not on the checklist because it's not common to every lift service in Peters, serviced by Peters, is simply not credible. In oral evidence, he prevaricated over and didn't answer the question, are such switches present in the majority of lifts you service? And he agreed he could either have written down not applicable, NA, if there hadn't been a fireman's lift in any particular building, or have written fire control switch in the free text form on the left. Asked about the defunct fire control switch on the walkway level, he thought he probably had seen it, but didn't record it or recommend its removal to anyone. This is incredible. Mr. Wallace recorded nothing about the very recent works to the lifts in April 2017. Asked about the email of the 28th of June from Philip Edwards, his line manager, in the aftermath of the fire, Mr. Wallace admitted that Mr. Edwards had asked him whether he had checked the switches and had told him, I actually checked them, yes. But he told the panel, I don't know what he means by both, it was just the one switch. We submit proper inferences to be drawn from all this evidence, including the contemporary, albeit hearsay evidence, of what Mr. Wallace said in the aftermath of the fire, that's the email of 28th of June 2018, include, 1, that his evidence is so unreliable that no weight can be given to it. 2, that he wrongly thought there were 2 fire control switches serving the lifts in Grenfell Tower. 3, that he falsely asserted he had checked these switches when asked by Mr. Edwards. And 4, he's been lying about it ever since. If the panel are not prepared to draw those inferences, we submit Mr. Wallace's evidence of testing the fire control switch in April and May 2017 is unreliable in the absence of documentary corroborative evidence of which there is none, and on the balance of probabilities, he did not do so. Mr. Fallis-Taylor's statement, so I'll deal with very shortly. He wasn't in post before the fire, and the FBU submits his partial and self-serving assertions relating to the fire control system are all based on hearsay and speculation, not on what he saw, did or heard, and should be disregarded as unreliable. I refer to our written submissions for the details. It follows in our submission there is no reliable evidence to support Mr. Howkins' assumption. If the panel find the fire control switch was blocked with builder's debris, as we've submitted, then the case is even stronger that neither Peters nor Bureau Veritas lift engineers tested the fire control switch in the run-up to the fire. Any competent lift engineer who inspected the lifts and tested their firefighting features in the months leading up to the fire could reasonably be expected to have observed at least 3 defects, none of which were noticed or reported. 1, the fire control switch on the ground floor was stiff and difficult to operate, and then upon rudimentary inspection that it was damaged and blocked with debris, and to have reported the need to clean and repair or replace it. 2, the fire recall function was disconnected, and upon rudimentary inspection that the wires had been cut with straight ends, and to report the need to reconnect it. 3, the disconnected fire control switch on floor 2 should be removed. Finally, so the what I call the disgraceful reconnection. The inquiry might also conclude that the fire control switch should not have been reconnected in August, caked with builder's dust and debris. Whoever reconnected it should have ordered a new one, or at least cleaned and tested the existing one. Reconnecting it in that state showed a shocking disregard for an essential firefighting feature of the tower, and so also for the safety of the residents. It's no surprise that the person who reconnected the switch has not yet come forward or been identified. that concludes our oral submission, sir. Thank you.
Good. Well, thank you very much, Mr. Seaward. Well, that concludes the oral closing statements in relation to Module 3. The inquiry will not sit tomorrow, but we shall sit on Thursday when we shall hear some opening statements in relation to the firefighting aspects of Module 6. So we shall rise at that point and resume hearings at 10 o'clock on Thursday morning. Thank you very much.